Our next speaker is Mark Morrison of Blake Cassels Calgary, Canada office. Mark has a white-collar crime practice and also works in anti-corruption, competition, and commercial litigation. He has substantial trial experience and has successfully represented clients at all levels of Canada's courts. Mark has also directed numerous multi-jurisdictional internal investigations for public and private companies, which is the focus of today's topic. Please welcome Mark Morrison. If I could also just, if folks wouldn't mind turning their cell phones off, if you're not going to turn them off, put them to vibrate. That way, even if you're not enjoying the presentation and your phone goes off, you'll smile and they'll think you like what they're hearing. Yeah, please just be respectful with the phones. Thanks, sir.
Thank you very much for the kind introduction, Lou. So I'm here today to speak with you about independent investigations. I've got to give the caveat, you know, when you see a DOJ lawyer talk, they always give the caveat, these are the views of my views personally, not that of the department. My caveat's a little different. There will unfortunately be no Jack Nicholson references during my presentation, so I apologize for that in advance. What I do want to do, I'm going to do two things. I'm going to start with a case study which is unfortunately a bit of a cautionary tale, which shows the dangers of not doing a proper independent investigation. And then after that, I'm going to try and speak to some of the considerations which arise when you are doing an independent investigation. And the reality is here, and I'll hit it right off the bat, there's no cookie cutter formula, there's no one size hits all investigation. What there are, though, are a number of the same kinds of considerations which arise in any sort of sophisticated investigation. So those are the kind of considerations I want to raise. So it's really about issue spotting. If you're in the unfortunate role of in-house counsel when one of these issues arises, you need to be thinking through the kinds of considerations which arise. So the cautionary tale. Now, I've bent over backwards not to use the name of this particular company because, quite frankly, they had such a reputational hit which arose from not doing the proper investigation, and I don't want to pile on. I think for most people in the room, it'll become fairly obvious who I'm talking about. Their issue, in most situations, you know, if you wind up on the front page, if it's a New York Times expose piece which is talking about a widespread bribery scheme in Mexico, normally that would be the news. In this case, that news was secondary. The widespread bribery scheme was nowhere near as fundamental or at the heart of the issue as the fact that the company was accused of covering it up. When you're talking about reputation, a company's reputation, it goes to the heart of it goes to issues of integrity, shareholders' trust in management and the senior officers. And unfortunately, the issue for this company was the bribery became secondary to the fact that they didn't deal with it properly, and as a result opened them up to accusations of a cover-up. The case itself, or the allegation, just real quickly, you had a disgruntled former employee, a senior lawyer in Mexico, came forward to the company headquarters in the U.S., said, look, we know that you guys are excited about this phenomenal growth in Mexico. Well, it all came about because of this widespread bribery scheme. The company in the U.S. says, oh, this isn't good. So they go and they do what you would expect. They go to a well-respected law firm with FCPA experience, and they get a work plan. They get a budget. Well, for those of you who've had the bad luck of actually living through these FCPA investigations, when you're talking about a work plan or a budget in this world, I mean, the costs are extraordinary. The work to be undertaken is extraordinary. General counsel gets that, and says, oh, you know, a little sweat down the brow, so that doesn't seem like such a good idea. So they he says, you know what, we've got a security group. I've got ex-FBI officers working for me. I'll get them to look into the issue first. We'll do a preliminary dig. And I'll pause at this point because, quite frankly, that's okay. In my view, that is a very reasonable and rational response. You don't need to immediately fly off and do a full extensive internal investigation. Testing the issue is fine, so they do that. The problem is their investigator comes back and says, yeah, I think we got a problem down there. Found about $24 million in unauthorized payments or payments we have questions in relation to. My suggestion is now we need to do the full independent investigation. And here's the point on the road. Here's the point on the road where there's the right way to go or the way that lands you on the front page of the New York Times. In-house counsel says, yeah, you know what, I still really don't like the cost of this thing. Let's put it in the hands of Mexico General Counsel. I mean, we got this whole legal group down in Mexico. Well, the biggest problem with this whole decision is that when the allegations are brought forward about the bribery and corruption in Mexico, there were specific people who were alleged to be at the heart of it, And the Mexico General Counsel was one of the implicated parties. So they put the investigation in the hands of the fellow who's engaged in the bribery. And lo and behold, and I'm sure everyone will be shocked to hear, a few short weeks later, the Mexico General Counsel issues a very short and thin report which completely exonerates the Mexican officials in the company and, of course, blames it all, lays it all at the hands of the disgruntled employee. Well, things are bad enough there. The investigator who did the initial preliminary review says, wait a minute, this is totally lacking. This doesn't cut the chase. You guys need to go to the outside firm. And now the senior execs of the company are faced with a decision. Well, yeah, we could tear things apart. It'd be disruptive. It'd be costly. Or we've got a nice, easy out here. We've got a nice little report. I think we'll just rely on the nice report. All well and good until you wind up on the front page of the New York Times. And just in terms of the consequences of this one are not even close to being done yet. But in terms of immediate consequences, after that expose piece, company share value dropped 8.2%, which for that particular company translated into a $19 billion loss in market cap. So these decisions had a $19 billion price tag to them, leaving aside the fact that they now have the DOJ crawling all over them. So the independence is the obvious key piece here that I want to highlight. And really it goes to the heart of why you need to do things right. You need to do things right so that when that scenario arises, the inappropriate conduct is not tied up with senior management. It's not tied up into the company's decision making. The company has kept the distance by doing things correctly to get to the heart of the problem, to fix the problem. So talking through then, what are some of the mechanics things you should be thinking about then when you're running an independent investigation? I always start with the why, because the downside, and part of the reason people are so hesitant to get into these independent investigations is they can be absolute monsters. They can be the mushroom cloud that just keeps going and going. They can spin out of control. The costs can be out of this world. There's a real risk of the never-ending story, which people don't want to be part of either. That's why the discipline of the why. Identify why you're doing this investigation, and then every step of the investigation needs to be tested constantly. If you're in-house counsel, you do need to push your investigators, your lawyers. You got to say, hold on, you want to go to Timbuktu to interview these 14 people? Why? And if you're the lawyer, you need to be able to say, these interviews are important for this reason. Boom, boom, and boom. And typically the boom, boom here is because you're trying to identify the scope of the problem. What is the problem? How far-ranging is it? Who's involved? How high up the company does it go? For the purpose of putting a fence around it, ringing it off, putting a stop to any conduct that's going on, figuring out how are you going to deal with the regulators, the authorities, putting in place proper compliance procedures, dealing with the company and individuals involved. Those are the kinds of things you need to be looking at and dealing with, but you need to have the discipline of making sure that your investigative steps are all going to help further those causes. So I talked about in the the unnamed company situation. When do you trigger? When do you have to go into an internal investigation? Some level of preliminary review is fine, but the kind of scenarios that should lead you to an independent investigation, if these are reputational issues going to the heart of the company, that's where an independent investigation is important. If there's potential criminal or FCPA issues, those are the kinds of things that should push you to an independent investigation. Or the other one is if it's senior officers of the company that are at the heart of the allegations. You cannot or should not be setting up a situation where an employee is effectively investigating their boss. It doesn't work. So, in terms of I'm going to run through a number of considerations. Who directs the investigation? Typically, when you're talking about a serious sort of board-level crisis emergency type issues, typically we'll deal with special committees of the board or an audit committee of the board. Does it always have to be the board? No. It's entirely appropriate in a lot of cases for the Office of General Counsel to direct an investigation so long as they're not investigating the conduct of their bosses, the CEO. Even if you are going to have the Office of General Counsel conduct the investigation, our typical practice, and I think it's good practice, is to make sure the board knows about it. You at least have given a heads up to whether it's the chair of the audit committee, chair of the board. You do not want to be in that position as in-house counsel where you sheepishly, the issue you thought you were controlling, the small mid-size issue, all of a sudden blows up to be a front page New York Times type issue and the board is caught unawares. When should outside legal counsel be brought in? live question and you're going to see, you'll see outside counsel saying, oh, you got to call counsel right away. No, as I say, some testing is fine, but effectively there's 3 reasons you bring in outside counsel. Number 1, the independence piece, which really goes back to the cautionary tale. When you need that independence, that's when you bring outside counsel in. Expertise. These investigations are complex, complicated. You want to hire the right people who've done these things and knows the kind of considerations that you're going to face. So a lot of times, especially in the age where now everybody's trying to shrink the legal spend, we'll just deal with it internally. Well, having an internal, someone whose background in corporate commercial law try and run a sophisticated investigation is not a good idea. And then the third reason is the protection of privilege. We heard earlier about some of the challenges of maintaining privilege in the investigation context. And certainly privilege can be maintained if it's directed by the Office of General Counsel. You don't necessarily need to have outside counsel come in. Having said that, it's cleaner, it's easier, and you can better justify your claim for privilege if you do have an outside law firm directing the investigation. And in that respect, one of the things we do right from the start, and we suggest, is defining and building that zone of privilege, the privilege protocol, right off the bat. You're going to set up your scope of investigation right away. Your scope of investigation should make it clear that what you're doing is either A, for the purpose of giving attorney-client advice, or B, in dominant contemplation of litigation, or some combination thereof. You right from the start, you got to be looking at this, how do I protect privilege? And then you need to be smart and practical about things. Inevitably, these issues arise as it's a bunch of ants coming out of the anthill. It's going crazy. Well, you need to keep your investigation team tight. You can't have everybody involved, everybody under the tent, because then what happens in this world of emails, we got emails flying right, left, and center, and a waiver of privilege, which is exactly the danger trying to avoid, occurs. So keep the team tight and try and keep discipline in communications. Keep email traffic to an absolute minimum. Don't send sensitive information about the email. I love the tip about the red paper. I hadn't heard that one before, but that's a good suggestion as well. Reporting, which do as much reporting verbally as possible, not in writing. I mentioned media consultants. I'll just raise that as a side issue. That's really part of this overall proactive strategy of identifying, thinking 2 steps down the road, where could this thing go, and trying to get out in front of it. For lawyers who've spent a lot of time dealing with media consultants, you'll often have different goals, and it can be, it's often a bit of a give and take scenario, but it is something worth thinking about. The investigation bar has now gotten so sophisticated when we talk about evidence preservation and collection. It is important. This is the value of dealing with people who have been down this road. You need to get out there right away with imaging of computers, backups of systems. Obviously there's data. You've got to have your data or your document hold notices. Now, having said that, a lot of people call document hold notices effectively document destruction notices. My own practice, when we can, is to get in there even before the document hold notice with the imaging and the backups and backing up the servers. But both of those steps have to happen right off the bat. Witness interviews. This is another one where you have to be very careful, and there's different strategic considerations which come into play. We're big proponents of face-to-face interviews when there's serious issues of credibility at stake in particular. Now, this is where you get a lot of pushback, and internal client will say, well, wait a minute, do I really have to fly you to Timbuktu? And it's not always the case. We're doing a bunch of video conference interviews on Monday, which it's not perfect, but at the same time, who's kin who? It's in Western Africa, and there's not a way in hell I'm going to West Africa right now. Leaving that little segue aside, no, you know what? There's times when you have to deal with the practicalities, and in an investigation, nothing's ever perfect. You're trying to maximize what you can, but the flip side is, in terms of that, when issues of credibility arise, we've been in interviews where there's one it comes to mind very clearly. It's in a foreign language. Everything's translated. You can't even tell what she's saying, but you watch the body language, and body language can be so crucial in this world because when everything changes, when you get to the sensitive parts, there's a lot you can take from that. Oh, and sorry, the last point that I should have raised there is, and I'm sure most counsel here would be very familiar with Upjohn warnings, but crucial that the witness knows right off the bat, you're the company's lawyer, you're not the individual's lawyer. Everything they tell you is you've got to share with the company. The privilege belongs to the company. The company can elect to do whatever they want with that information, including waive that privilege. crucial. The last thing you want to do as counsel is get yourself in a position where that witness is going to allege down the road that you were their counsel and you've now breached the law society or attorney-client privilege in sharing information. Employees who ask for independent counsel can often be a bit of a pain. Having said that, sometimes you need to deal with it. In an ideal world, when you're trying to get the bottom of things, you really don't want to have to go that route. But there are times where you've got employees who might have their own personal liability issues, or you've got scenarios where there's a clear adversity of interest. We try and manage the process as much as possible. I mean, if you're better off putting them in the hands of somebody that you can deal with and trying to get out ahead of the issue than, flying to Timbuktu and all of a sudden realizing you can't go forward with your interviews. Third parties, this goes to the point of the imperfection of the interview process. A lot of times there will be third parties out there who are going to have all sorts of great information you want. A lot of times, however, you're dealing with an amazingly sensitive issue that if it gets out there could get your company in serious criminal jeopardy and also wind up on the front page of the New York Times. A judgment call. Sometimes you just have to say, you know what, it would be ideal to talk to that person. It's not worth the risk. Those are the kind of things you need to think through, though, depending on your circumstance. This one, when I talk about international matters and retention of local counsel, this one is so crucial because, quite frankly, as North American lawyers, and I'm lumping us, the Canadian lawyers, right in there with the American lawyers, we can be so myopic at times. We can be so focused on our own laws that we absolutely forget that there's actually the conduct in place when we're talking about, for instance, foreign corruption matters. The conduct occurs in far away in countries that have their own laws and where their own laws have been broken. And we tend to drive right by that because we get so focused on, FCPA or Canadian laws. And the reality is, a lot of times, the consequences in the local country can be a lot even worse than some of the harsh and draconian FCPA penalties. If your only assets are in a country where the country is just looking to appropriate your assets right, left, and center, well, you better get some local counsel to consider those that kind of issue. And you also need to be mindful of what kind of rules even might govern the investigation. Great example is Mexico. We've run a number of investigations in Mexico. Well, the kind of imaging and data collection you would do normally and just bring in the information back, well, in Mexico, it's an offense to bring that information back across the border. North American lawyer can easily get himself and his company way offside because they didn't check with Mexican counsel. So it's a good reason. Make sure you're speaking to local counsel. A real key one is this notion of drawing an end to the investigation. And this circles back to the point I was talking about, these mushroom cloud, ever-expanding investigations. It is really, really hard to say enough is enough. And lawyers we're inherently cautious. We want to pick up every pebble on the beach. We're really, in this context especially, where you're never going to have perfect knowledge. You need to understand going into an independent investigation. You're never going to know everything. And so there's a point of diminishing returns which comes with every investigation. And this is where I go back to the discipline from the start of saying, what's this step? How is this step going to advance my goals? If this step is not advancing my goals in the investigation, then it shouldn't be undertaken. And there's a point you got to draw the line. Last point I'm going to make is reporting. You've got competing considerations in reporting. On the one hand, you've spent all this money and all this time and effort doing all the right things. You want to document you've done all the right things. You've got to report to people. You want to explain to them what's happened, what your findings are. All of that sort of militates towards what we lawyers love doing, the 100-page detailed report. Well, the flip side is these are very, very sensitive issues, and the risk of leakage and the risk of criminal prosecution and the risk of being on the front page of the newspaper are such, you don't want that kind of stuff floating around. There's no perfect scenario, but what we will often do, and I came back yesterday from doing just this, we'll do an internal PowerPoint. We'll present to the client, to the board of directors, and we'll walk them through the PowerPoint. They won't get a copy of it. We'll keep the copy. We keep it in our privilege file. If they ever need it, if they ever need resource to the information that we've got the documentation, but the company has no report. There's no paper to be lost. So I've got in the materials you'll have there's some other considerations which arise, but I wanted to cover the waterfront a little bit of the types of things you need to think about if you're ever faced with these sensitive reputational or criminal issues which give rise to the need for an independent investigation. I'll also be around, no doubt, enjoying a beverage with many of you later, and don't hesitate to ask if you have any questions. Thank you very much for your attention.